My name is Jeff Morgan. I'm from Dallas, Texas. I want to read a letter that was written by Beverly Willett, Esquire. Beverly Willett, Esquire. This letter was actually written on April the 26th, 2021, and it pertains to the issue of no-fault divorce. She wrote this in support of Representative Matthew Krause and on behalf of one of the bills that he was submitting to the legislature. And she says this: Dear Mr. Krause, I write in support of HB 3188, the proposed bill to remove unilateral divorce as a cause of action, and HB 3190, the proposed bill to extend the waiting period for divorce, except in cases of family violence. These bills would serve the public policy of Texas by promoting marriage and protecting families and children. As such, they are aligned with Title I, Subchapter B of the Texas Family Code. The first thing that I find interesting was that Representative Krause had submitted a bill to repeal no-fault divorce. In Texas, we call it insupportability, but Beverly Willett was actually very correct when she said this: I write in support of HB 3188, the proposed bill to remove unilateral divorce as a cause of action. See, many people are under the impression that no-fault divorce means that two people just can't get along and that they both mutually decide to get a divorce. That can happen, but in many cases, perhaps even in the majority of cases, and according to some people, in the vast majority of cases, no-fault divorce has become the provision under which people file for unilateral divorce, forced divorce, divorce on demand, divorce against which there is no defense. Even if one person says, wait a minute, I don't want the divorce, tough luck. You can say nothing about it. There is a predetermined outcome, there is a predetermined verdict, and Beverly Willett experienced this herself, and she, as an Esquire, wrote in support of Representative Krause's bill. According to the latest U.S. Census, the divorce rate in Texas is statistically higher than the national average. While the overall divorce rate has declined, the marriage rate has declined along with it. This is extremely troubling, and yes, it is very, very troubling. We know that the fallout from no-fault divorce has been financially, emotionally, and physically devastating to divorced families. And people always say, well, if the parents can't get along, we need to look at the best interest of the child. The best interest of the child, in almost every instance, is to be raised in an intact family with his or her natural mother and father, period. There is no second best interest of the child. That is the best interest of the child, to be reared in an intact family with his or her natural mother and father. By contrast, overwhelming research establishes that marriage produces better outcomes for men, women, and children. Indeed, it is the gold standard in terms of child outcomes. Children who grow up in intact families are more likely to achieve higher levels of education, in turn increasing their odds of marrying and having higher incomes, thus continuing a cycle of wealth and health for their own children. However, children from divorced homes are far more likely to experience poverty, drug and alcohol problems, juvenile delinquency, aggression, depression, reduced educational attainment, teen pregnancy, and more. Studies show that most divorces involve low-conflict marriages, and that these divorces, the divorces with low conflict, but the no-fault divorce nevertheless, the divorce on demand, the divorce for any reason for no reason, the forced divorce, when there is low conflict and somebody files for divorce, those divorces are the most devastating on children. And she references an article in the New York Times. Moreover, unilateral no-fault divorce laws violate the U.S. Constitution. The 14th Amendment mandates that no person shall be deprived of life, liberty, or property without due process of law. The amendment's procedural protections include the plaintiff's obligation to assert grounds, the defendant's right to be heard, including the right to cross-examine and call witnesses and offer evidence, and the right to impartial decision-making. Impartial decision-making by a judge who should be impartial, who should listen, who should not say, boy, I have to grant a divorce, as I know at least some judges believe, I have to grant a divorce. That is not impartial. That is a predetermined outcome. Judges that follow the predetermined outcome are not exercising the judicial role properly. But spouses unilaterally sued for divorce have no right to their day in court. And this is true because if you are sued for no-fault divorce, and remember, no-fault divorce, unilateral divorce, divorce on demand, it is a lawsuit. And in any lawsuit that you have in front of a court of law, you should have the right of defense. You should have the right to present evidence to exonerate yourself. You should have the right to call witnesses. None of this stuff matters in divorce court. None of this stuff matters in family court. You do not have this. There is a predetermined outcome. There is no due process when it comes down to unilateral divorce. The state will always, almost without exception, grant divorce in favor of the person who wants a divorce. Period. Even if there is no need, doesn't make a difference. The state will grant the divorce, will let that person win the lawsuit with almost without exception, and then also give him or her cash, prizes, often a house, cars, children possession, and stuff like that. No-fault divorce is the big evil in American society. It is a huge evil in the state of Texas. Only one spouse need allege that the marriage has become irretrievably broken. What exactly does that mean, irretrievably broken? Nobody knows. I've talked with people that have had their marriages irretrievably broken who have then gotten remarried to the same person from whom their marriage was irretrievably broken. It was insupportable. There was no possible way that their marriage could be saved. And yet after they got the divorce, they got remarried. How is this possible if the marriage was irretrievably broken? Either somebody lied in the court or the judge judged incorrectly, and the attorneys were advocating for something that they knew or maybe have suspected was false. There is no test to determine whether a marriage is irretrievably broken. It is only the testimony of one spouse. I just believe it's irretrievably broken. Oh, okay, so we are going to rule with your belief, even though your spouse says it's not irretrievably broken, he or she does not believe so. The judge will almost always, once again, without exception, rule with a spouse who says, well, I think it's irretrievably broken. Can you say those magic words, irretrievably broken, insupportable? You say those words, you get your divorce. Only one spouse need allege that the marriage has become irretrievably broken, termed insupportability in Texas. No allegations of harm or misconduct are required. Well, you know, what about the situation where there's spousal abuse or there's domestic violence? That is a fault-based reason. No fault divorce, forced divorce, divorce on demand, divorce for any reason or for no reason. That does not include domestic violence. Domestic violence is a fault-based reason. That is something that somebody has been beating you and you seek to separate from that person for your own protection. Same thing with adultery. Adultery used to be criminal in the state of Texas. We have decriminalized adultery. Adultery is really no big deal. And yet when it comes right down to it, adultery is one of the biggest reasons that marriages fall apart. But we can't say that the marriage fell apart because of adultery. We have to say that it was insupportable. It's like nobody was at fault. Well, wait a minute. Had you not been cheating on your husband or had you not been cheating on your wife, there was not a problem. Oh, but no, it's really, we were cheating because of insupportable. I don't know which came first, the insupportability or the adultery or the insupportability, but insupportability. We don't want the children to know that maybe adultery took place because that would be something that the children shouldn't know. So we're going to lie to them and let them know that the marriage was really just insupportable. It wasn't because of adultery, and it wasn't because of physical abuse or anything like that. The reality is that most children know that there's been something going on. Not all, but most people know, most children know that, and they are taught from a very young age to distrust the judiciary, that judges will lie. Judges will lie to supposedly protect children. Our justice system, when it's based on a lie, is not justice, it is injustice. No allegations of harm or misconduct are required. Innocence counts for nothing. An innocent spouse can be kicked to the curb, can lose his or her house, can lose daily contact with his or her children, can be forced to pay child support, can have all sorts of things happen to him or to her, be thrown into jail even, have a protective order put upon him or her, and yet he or she has done nothing. It's just because the person who wants to have an affair, to move on to Mr. or Mrs. Moneybags, whatever the case may be, wants to move on. This is injustice. This takes place on a daily basis in the state of Texas. The word of the person who wants a divorce is enough to end a family. And remember, divorce is not just between two people. Divorce affects children. Divorce affects grandchildren. Divorce affects in-laws. It affects relatives. It affects everybody. And yet one person can say, well, I just believe our marriage is insupportability. No proof necessary. And that person has the ability to destroy many, many people. And the judge, once again, due to our legislature, which has written this very poorly phrased statute, will grant a divorce. Our legislature is responsible for this as well as the judges. The judges should not be granting insupportability. They should at least say, give me some proof. Give me some proof that the marriage is insupportable. They will never ask that. Attorneys won't ask that. Well, attorneys, we want to have insupportability so that we can not have to rack up the attorney fees. They will promote injustice while they are financially raping and pillaging a family. The person who wants a divorce, the word of that person alone is enough. This is the very definition of injustice. And when our family courts, or when any courts do not dispense justice, they often end up dispensing injustice. And then they wonder, well, why don't people trust the process? Why don't people trust judges? Why don't people trust attorneys? Why don't people trust the judiciary? Why don't people trust the legislature who wrote these horrible statutes? Why don't they do that? Because they're unjust, and people know that. Many people know that. We've tried to find ways to put lipstick on the pig of injustice, but no matter how much lipstick you put on the pig of injustice, injustice is still injustice. The current law also transgresses the Constitution's guarantee of substantive due process. So first you talked about the procedural due process, now the substantive due process. In the decision legalizing same-sex marriage, Obergefell v. Hodges, 576 U.S. 644 to 2015, the U.S. Supreme Court reiterated the fundamental right to marriage and its sweeping benefits. Everything from companionship and security to safeguarding children to tax, inheritance, health insurance, and myriad other benefits. No-fault divorce takes all of these benefits that Obergefell argued for, saying, well, we have to have same-sex marriage because it would be discriminatory against two homosexuals or two lesbians not to give them the protections of marriage and all the sweeping benefits. And yet, what they've done is they've said, no-fault divorce has said, that's okay for gay couples, for homosexuals, for lesbians, for whatever else it may be. But if you're in a marriage that you have pledged, made a vow before God, made a vow to the state, you have no defense. You cannot protect your children. You cannot protect the tax, the inheritance, and the other things that accompany it. This is the evil of no-fault divorce. No-fault divorce renders these rights hollow, requiring forfeiture without cause and without compensation. And the issue without compensation, in most contracts, if you enter into a contract with somebody and you break the contract, you are required to provide him or her some compensation for breaking the contract. Well, we had this contract and I decided I wanted out of it. Fine, but this person was relying upon the contract. Marriage is a contract. And if you're going to break the marital contract, there should be some type of compensation rendered to the spouse, and I believe also rendered to the children. If you invoke unilateral no-fault divorce, divorce on demand, divorce for any reason, for no reason, you can make up a reason, forced divorce. That's our policy in the state of Texas. And our legislature just think, well, that's okay. We've got to allow this type of divorce to take place because if we don't, we might perpetuate domestic violence. There might be some other thing that may happen. The legislature is willing to sacrifice many, many marriages, many, many children, many, many grandchildren. They are willing to disrupt society because of a hypothetical that may happen. And yes, it may happen, but the reality is our legislature, our judges, our attorneys, our so-called family law attorneys, they are responsible for far more damage, destruction, devastation, and crime than any of these so-called marriages that might lead to some type of domestic violence and something else. The Supreme Court held that marriage forms a union greater than two persons and constitutes a keystone of our social order. Our legislature is willing to disregard and to dismantle this keystone of our social order for the sake of no-fault divorce, unilateral divorce. By very definition, then, Beverly writes, no-fault divorce is anti-marriage. And it's not just anti-marriage, it's anti-family. It's anti-societal order. It's anti the very foundational building blocks of society. In addition, she continues, we know from research that longer waiting periods reduce divorce, and this is true. You can look throughout the states and find out which states have shorter divorce waiting periods and which states have longer divorce waiting periods, and you'll find that there is a correlation between longer waiting periods and reduced divorce. Longer waiting periods reduce divorce, encourage reconciliation, and allow time for parties and their children to adjust and for cooler heads to prevail. House Bill 3190, and this is again from the last legislature, will further these goals. She continues further. For decades, I was a practicing lawyer in New York City. Although I no longer practice law, I have been a lawyer in good standing and a member of the New York Bar since 1982. I am considered a national expert in divorce and reform legislation, having written widely on the subject and have been consulted about similar legislation in South Dakota, Georgia, and other states. Along with other lawyers, marriage educators, domestic violence experts, and others, I helped craft both the Parental Divorce Reduction Act, this was the model legislation that she helped to craft, and the Second Chances Act, legislation which was drafted by former Chief Justice of the Supreme Court of Georgia, Leah Ward Sears, and Professor William Daugherty. I co-founded the Coalition for Divorce Reform to advocate for divorce reform and educate the public about marriage and divorce. And she gives a website link here. I have written about the pitfalls of divorce for the nation's top publications, including the New York Times, the New York Post, the Daily Beast, the Washington Post, Newsweek, USA Today, the Huffington Post, and more. Attached are copies of my articles for the New York Post and the Washington Examiner regarding the unconstitutionality of no-fault divorce, unilateral no-fault divorce. I am also the author of the 2019 memoir, Disassembly Required, a memoir of midlife resurrection, recounting my struggles to start a new life after my children and I suffered the devastation of an unwanted divorce. And not merely the devastation, but the injustice of an unwanted divorce. Kirkus Reviews said this, in 2009, 6 years and 7 judges after Willett discovered that her husband, Jake, was cheating on her, a divorce decree was issued. She was 53 and unemployed. She had not wanted the divorce and did everything she could to fight it. The legal skirmishes surrounding the divorce offer an illuminating backstory that highlights the changing ethos in the family court system of the new millennium. And Beverly finishes with this final sentence, I hope the legislators of Texas will be the first in the nation to take the brave step of repealing unilateral divorce, upholding marriage, and restoring fundamental fairness in our family courts. Respectfully submitted, Beverly Willett, Esquire. The problem we have in Texas is that in our Juvenile Justice and Family Issues Committee, we have, in this last session, we had 3 attorneys that were on the commission that dealt with family law. The chair, Representative Victoria Niave, was a practicing lawyer, and among her practice was family law, divorce, those types of issues. Anna Maria Ramos was a full-time divorce attorney. David Cook, he was a Republican. The first 2 were Democratic women. David Cook was a Republican. He has a law firm that handles divorce. And then we have Gene Wu. Gene Wu was an attorney. I believe he does some stuff with CPS. I'm not sure all of his background. But we had attorneys there trying to determine what was best for you. We had attorneys there, at least 3 of them, that would profit by prolonging divorce, by allowing divorce injustice to continue. quoted in Article 3, Section 22 in our Texas Constitution, these three legislators: Victoria Niave, the chairperson; Anna Maria Ramos, a divorce attorney; David Cook, a man who owns a law firm that deals with divorce. They should have disclosed their interest in this legislation, and they should have recused themselves from voting on this legislation at all, period. This was a conflict of interest. If you look at what the Association of Certified Fraud Examiners say, when you have conflicts of interest, when you have people voting on things that may enrich them personally in their private life, that is called corruption. So yes, I can accuse Anna Maria Ramos, Victoria Niave, and David Cook of possible corruption. And I believe that that's exactly what they did. They should have recused themselves. We need to make sure that these people are not again on the Juvenile Justice and Family Issues Committee. Anybody who has an interest in divorce, who may profit by allowing unilateral divorce to continue, needs to be recused from that committee. They need to disclose their interest, and they need to say, I cannot vote on this. And David Cook, you've addressed me personally. Anna Maria Ramos, you have. Victoria Niave, all three of you have done so. You know that what I'm speaking is the truth. You have been guilty of corruption, and I would be very glad to talk with you further about it. But usually what you do is you shut me up instead. Anyway, this again was written by Beverly Willett, an expert in divorce reform legislation and a coalition to reform divorce laws, a person who argues that not only is this unjust, it's unconstitutional, it destroys family. Thank you, Beverly, for this letter. And I hope, again, we're coming up to the upcoming legislature. And I know many of us will be down there once again. We need some brave people to sponsor this legislation. There's a few people in mind that I have. People that would say, yes, this is absolutely correct. This is a violation of your constitutional rights. We will help to protect families. We will help to protect children. We will not look at the bogus arguments that the Texas Anti-Family Lawless Foundation and their lobbyists, Steve and Amy Bresnan, and the attorneys and the judges that they pay to come down, or if they're not paying them, they're at least, please come down and testify on our behalf, because we need somebody to make us look like we're legitimate. We need to destroy the other side. These people are anti-family people, anti-family attorneys, anti-family legislators, anti-family lobbyists, anti-family judges. We need to be standing up for families. We need to be standing up for children, our grandchildren. We need to be standing up for innocent spouses. And that's all I have to say there. Once again, Beverly, I thank you for this letter that you sent. My apologies that I was not able to read it last legislative session. Look forward to getting the legislation passed in 2023. Thank you very much.